And I'm Director of U.S. Studies here at the Wilson Center, and I'm happy to welcome you to this session, this discussion of a new book edited by Doyle, Secession as an International Phenomenon from America's Civil War to Contemporary Separatist Movements. Before I say a little bit more by way of introduction, let me just point out that you have in front of you bios of the speakers and also on the green sheet a list of our upcoming events. And I hope that we'll see you at many more of these. We have a lot of very interesting things on our calendar. The Wilson Center, as many of you know, was founded in 1968. Oh, I forgot to give the 2-minute warning. Wait, this is being taped. Is it? I guess it's being taped. Okay, sorry. The Wilson Center, as many of you know, was founded in 1968 as a living memorial to President Woodrow Wilson. And in keeping with his career as both a scholar and a public servant, the center aims to promote dialogue between scholars and policymakers around a range of subjects. Today's event is very much in the spirit of that mission. Don Doyle's edited collection, Secession as an International Phenomenon, begins with America's Civil War, something that has, of course, been the focus of a great deal of historical scholarship. But it also shows how the idea, the phenomenon of secession, is relevant to a number of different contemporary geopolitical struggles and thus has implications for the foreign policy of the United States, among other nations. Today's discussion also helps us to develop a theme that's been running through a number of different U.S. studies programs over the past few years, namely the value of transnational and comparative scholarship for understanding American history, culture, and society. This series, and it's kind of an informal series, a sort of implicit series, but if you look back at a lot of our offerings, you can see examples of it. It's covered a wide range of topics and new publications, including an important book by one of today's commentators, Andrew Zimmerman, entitled Alabama and Africa, Booker T. Washington, the German Empire, and the Globalization of the New South, which was published by Princeton University Press in 2000. And this book examined the circulation of ideas about race from the American South to Togo. While Zimmerman's book falls squarely in what we would call the transnational camp of historical scholarship, Secession, the book we're going to be discussing today, takes a more comparative approach, looking at the U.S. Civil War within a longitudinal context that brings us from the mid-19th century to today and includes cases such as Taiwan, the Soviet Union, Kurdistan, and a number of other places that figure prominently in current geopolitical debates and thus are of great interest to both scholars and policymakers. By taking the long view, the book prompts us to rethink some received ideas about secession and perhaps reach some surprising conclusions about the nature and implications of secession as an international phenomenon and as a move undertaken by various groups aspiring to national identity. But I don't want to give away the conclusions to this book or the many insights that it has. I'll leave that to our speakers to explain. We're very fortunate to have with us not only the editor of this fine collection, Don Doyle, but also two commentators who will address the book from very different perspectives. You have the bios in front of you, so I won't take time to go through full introductions, but I do want to mention that Don Doyle has done pioneering work in using transnational and comparative approaches to link Southern history and the history of nationalism. And his current project on America's International Civil War will undoubtedly be a major contribution to this ongoing field of scholarship. Andrew Zimmerman, who, as I mentioned earlier, has also done path-breaking work in transnational history involving the U.S. South, has done some very interesting work, but he approaches this from a different angle, that of a German historian. He too is working on a transnational history of the Civil War. And I hope that when Don and Andrew both finish their books, they'll come back and we can have a session comparing the two of them. So you have a standing invitation. So you should both finish your books at the same time so we can do that. Oleksandr Merezhko brings the approach of international law to the proceedings. A distinguished legal scholar in both the Ukraine and Poland, he's considered the question of secession from both a political and, I suspect, also an experiential as well as a scholarly perspective. Both he and Don are currently in residence here at the center, and I know that they've had some fascinating discussions about their mutual interests in the question of secession. So today we'll have the opportunity to join them in that discussion with the added benefit of hearing Andrew's ideas as well. So I've asked Don to give us an overview of the book, and then comments by Andrew and Oleksandr will follow, and then we'll open the floor for discussion. As you probably saw on the way in, copies of the book are available for sale, and I'm sure Don would be happy to sign them afterwards. So, Don, you have the floor.
Thank you very much, Sonia, and thanks for setting this up, and thanks to the Wilson Center for sponsoring this, and to the University of Georgia Press, who bought lunch, I understand, and I'm very grateful for that. And I want to give a special thanks also to the National Endowment for the Humanities and two of its representatives, Joel Schwartz and Elizabeth Arndt, are here today. Please raise your hand. And I want to thank them for supporting this project. It was a conference that was held in Charleston now 4 years ago. And it was a, are we getting static?
Cell phones on or their Blackberries, please turn them off. That, I think, it causes the static. Sorry. Thanks. Sorry.
But I want to thank them for supporting that conference and therefore the book that came out of it, and for all of the really good work that National Endowment does for us, especially in the field of history. And thanks to my colleagues on the panel who are giving up their lunch hour to. And I look forward to your comments. I had become interested in this international phenomenon of secession. I know when it happened back in the spring of 1995 when I was in Italy. And at that time, the Northern League was on the rise and talking about secession of the North from the South. And I remember seeing in bookstores Alan Buchanan's recently translated book, Secession, and a book on the ethics of political divorce from Fort Sumter to Lithuania and Quebec. But it wasn't just in Italy. It seemed all of Europe at the same time that it was coming together under the European Union, was coming apart in places like Scotland, Yugoslavia, of course, the former Soviet Union, the former Yugoslavia. These formers now began to be prefixes to a lot of national names. And there I was in Italy as a Fulbright professor teaching Italian students the history of the secession and the Civil War in what could, if things had not gone, or if things had gone a little differently, been the former United States of America. And I couldn't help but think comparatively about these matters of state-making and state-breaking. Italy, remember, had just come together as a united nation, more or less. In March 1861, it was proclaimed almost precisely at the time that the United States was falling apart. When I moved to the University of South Carolina, it seemed to me like this was just an ideal place to discuss secession in what was the most spectacular episode of secession and civil war over secession in the 19th century and for a long time thereafter. And I wanted to bring together the historians who had studied the Civil War to no end, its causes and all of its various permutations, with this conversation that was going on in philosophy and in among legal scholars and also among political theorists. The Civil War that followed the secession of South Carolina in 1861 was a traumatizing experience for the American nation and for much of the world as well. And it just horrified onlookers in Europe, Latin America, elsewhere. It was the deadliest war in the Euro-American world since the Napoleonic Wars. And it seemed to presage this horrifying preview of the total war that was coming in World War I and in the 20th century. Except for the bloodbath in the Civil War between Nigeria and Biafra, the American Civil War remains the most deadly of all, at least in modern history, over secession. Over 600,000 men died. Millions more were maimed and psychologically damaged. it was about 2% of the total population. A comparable or proportional figure in today's population would be mortality rates of 6 million people. Last December, some of you may have read, I saw it in the New York Times, that Charleston held a secession ball celebrating South Carolina's beginnings as an independent republic of South Carolina, and reenacting the celebratory experience of 150 years earlier. The difference being that those people who were celebrating in the streets of Charleston with bonfires and torches and songs and so on, they didn't know that they were jumping off a cliff into a bloody chasm of civil war that would devastate South Carolina, the South, and the American nation. America's secessionist crisis did not encourage a lot of imitation, at least not in the United States, and not for a long time elsewhere. But there are today hundreds of different secessionist movements. They cover a wide range of different agendas. Some of them, I think, are nothing more than a website and a few fanatics stoking the fires of resentment and calling for separation. Others have a much more serious political and military, often terrorist, presence and potency. The varieties of causes defies any easy generalization. Some, of course, are ethno-cultural minorities wanting to escape or some kind of past or anticipated oppression, and others are ideologically driven. There's a great variety of secessionist or separatist movements. While most of the United States took a lesson from the Civil War and has not really used secession until very recently in Texas as a remedy for grievances against the central government, separatism became a common solution around the world. A solution to disagreements or injustices in a world that was now encased in nation states and was subject to the intrusion or jurisdiction of central governments in a wide variety of human activities, from education to wars to regulation of the economy and so on. Today, we estimated that about half of the United Nations members, which are now numbering 192 and counting, Sudan, Kosovo, others coming online, about half of them can be said to have begun as breakaway states, including our own, the United States of America. The United Nations began with 51 members in 1945. Membership passed 100 in 1961, 159 in 1990, and now passing 192 with, meeting 192 with Montenegro in 2006. Some, like the United States, emerged out of empires that were disintegrating through rebellion or through other forms of separation, and others broke away from territorially contiguous nations. Secession, according to the current theory that Buchanan and others are trying to develop, is a normal process, historically normal process that they're trying to understand, and they've adopted this term political divorce. And I think what they mean by this, of course, is no-fault divorce, not the War of the Roses, for those of you who remember that famous movie. Instead of letting each claim of separation be decided by blood, by warfare, by the violent passions of nationalism and separatism, I think the main thrust of the new debate among philosophers, political theorists, and scholars is to have some new rules, to set up some ethics, as they call it, for separation, to decide how to divide up the property, take care of the children, and go their separate ways. It was my goal in this conference and in the book that followed to try to invite groups that were engaged in intense and very interesting conversations about the causes of the American Civil War or some other secessionist movement with the theorists in philosophy and law and politics. First, I wanted to address the historians who were, as a discipline, they tend to want to study one nation at a time, one case at a time, often with no reference to the larger theoretical problems, much to the frustration of some of the more theoretically oriented people in the social sciences, law, and philosophy. And then the theorists who wanted to categorize different types of secessionist movements and the rationale behind them, often with a glance at history, but not a full appreciation for the nuances, the details of causation that historians are interested in. And then I had a special mission also to try to create more conversation between those who were devoted to the study of the United States and its past and the rest of the world. And I think that this problem, the isolation of America, doesn't come just from Americanists who are a little provincial, but also from historians and others in Europe who often see America as kind of detached and an incomparable example of some different kind of society. I'm very impatient, I'll say, with ideas about American exceptionalism. The U.S. Declaration of Independence has been downloaded, filled out, and copied by hundreds of independence movements. David Armitage, in his wonderful little book on the Declaration of Independence, lists some 400 declarations of independence, and that alone ought to dissuade people who believe in America's exceptionalism. America's other separatist movement, that is besides the American Revolution, the one of 150 years ago, equally famous as the American Revolution in many quarters, but a good deal less successful, at least for the South. That Civil War was a benchmark in the history of separatism, and the horrible price that was to be paid by a nation and its parts when reason did not prevail, when the rules, the ethics of separatism did not apply, and when passions got the better of the, as Lincoln called them, the better angels of our nature. The matter had to be settled in blood, not ink. The book, I can recommend you must go buy it and understand all of the variety and richness of the arguments of the 18 different authors, 19 including myself. I can't do justice to any of them by trying to summarize, but I'll comment a little bit on the American Civil War and urge you to refer to the book for some of the more nuanced and really interesting avenues that each of the essays pursue. Southern secessionists 150 years ago, from this very day, this very moment at least, very much were in agreement, as they met in Montgomery and then later Richmond, with the contemporary principle that secession, separatism is a normal path to state making or state breaking, depending on your point of view. The very term secession was deliberately introduced by Southerners to imply that this was not a revolutionary upheaval to overthrow the government. This was a peaceful, lawful separation, a withdrawal. The term goes back to ancient Rome, when the plebes of Rome would withdraw from the city in order to protest patrician legislation or rule or personalities. And it was often used in the 19th century to describe the division of religious groups, for example, over some doctrinal issue. And it was not, in other words, a takeover or a revolution, an effort to overthrow, but a withdrawal. And the word had peaceful and legal connotations. Many of the southern states, following the American example of 1776, declared their intentions to a candid world, in Jefferson's words. South Carolina led off in December 1860 with its declaration of the immediate causes which induce and justify the secession of South Carolina from the federal union, issued on Christmas Eve Day in 1860. And it borrowed not just the logic but the language of the Declaration of 1776 when it reasoned that, quote, whenever any form of government becomes destructive of the ends for which it was established, it is the right of the people to alter and abolish it and to institute a new government. Then it goes on to prove that certain conditions provided for in the U.S. Constitution had been violated in recent years. And then they presented evidence to a candid world. Well, they didn't use that expression, but essentially the same logic that Jefferson was using in his Declaration. All of the evidence presented had to do with the threat to slavery, beginning with the refusal of the northern states to enforce the the Fugitive Slave Law of 1850. They passed laws saying they wouldn't uphold it. And then it moved to less tangible damages. Northern states, the South Carolina document said, have, quote, denounced as sinful the institution of slavery. True. Then anti-slavery forces have elected a president, quote, whose opinions and purposes are hostile to slavery. This would be more controversial. Lincoln, of course, had not taken power, but it's true that he was anti-slavery and he had been elected. But up to this point, all of it had to do with events that had happened, however you interpret them. But then the Declaration shifted into future tense, predicting, quote, a war on slavery and the loss of self-government and self-protection, and finished by saying, quote, all hope of remedy is rendered vain. So it's the anticipation of this president and what is going to happen to South Carolina that justifies the act of secession. It's a preemptive secession, if you will. Now, this opens up some interesting theoretical problems that I think run through the book and through a lot of different secessionist movements in today's world or in the past. Separation is often justified as a remedy for abuse that has happened in the past, that the national regime is unfair to the minority or the colony or whatever it is, and you present evidence of that and you establish a just cause for secession. But do seceding states have to suffer the injustice in order to justify secession? Does Sudan have to undergo genocide, or any nation, before they secede if they have good reason to anticipate that they are in very serious jeopardy? Does just cause even matter is another question in the debate. Do you have to demonstrate a just cause? Can it just be pure choice? Cannot minorities who want to govern themselves simply say, we want to govern ourselves for whatever reason, past or future? Now, there's another, I think, more challenging and more complicated and historical problem here in the South Carolina precedent, and that has to do, of course, with slavery. Does it matter that they are declaring their independence to protect slavery? I think it mattered a great deal, but did it matter at the time, and ought it to matter logically to the argument for secession? If a seceding nation's intention is to impose suffering and abuse on a minority or a group within its nation, does that then render the claim to nationhood, to independence, invalid? Finish up in just a minute. Abolition, after all, was not a prerequisite for other nations entering the family of nations. It wasn't for the United States of America in the 1780s. It wasn't for Brazil in 1822, or many of the other Spanish-American republics who, at least at the time that they were founded and independent, still had slavery. It wasn't clear at the beginning to either the Union or the Confederacy that slavery was a disqualifying factor for recognition of the Confederate States of America. The Union wasn't sure that that was going to be an obstacle. The Confederacy simply chose to ignore it, deny it, talk about other things, at least abroad. Lincoln's argument against secession, meanwhile, was a legalistic constitutional one, not based on slavery, but on the condemnation of the South for wanting to disrupt the Union. In his first inaugural address, issued in March 1861, Lincoln guaranteed the safety of slavery in the states where it existed. And he said that he had neither the power nor the intention to disrupt slavery in those states. His objection to secession that he made clear in the first inaugural was that it was a revolutionary threat to the constitutional basis for the nation. Secession, he said, was the essence of anarchy. If any time a group didn't like the outcome of an election or legislation or the tariff, they threatened to secede or did secede, it would be the end of self-government. It'd be the end of any kind of nation. There was a revolutionary right to secede. The Declaration of Independence, after all, the nation was founded on that revolutionary right. But this was revolution, not a legal constitutional withdrawal, Lincoln insisted. By the way, the delegates who were meeting in Montgomery 150 years ago in March discussed the idea of including a secession clause in their constitution and immediately tore that up and abandoned it. This was no time for secession in a nation at war. In his address, Lincoln anticipated the metaphor of political divorce wonderfully, and in a way I think most of the theoreticians have forgotten, when he said, physically speaking, we cannot separate. We cannot remove our respective sections from one another, nor build an impassable wall between them. I think nowadays people do imagine we can build walls between people. But a husband and wife may be divorced, he wrote, and go out of the presence and beyond the reach of each other. But the different parts of our country cannot do this. They cannot but remain face to face. And intercourse, either amicable or hostile, must continue between them. Is it possible then to make that intercourse more advantageous or more satisfactory after separation than before? Can aliens make treaties easier than friends made laws? Lincoln closed with a memorable appeal to conciliation and reason, much also, I think, anticipating some of the philosophers and theoreticians who would like us to have an ethics of secession. I am loath to close. We are not enemies, but friends. We must not be enemies. Though passions may have strained, it must not break our bonds of affection. The mystic cords of memory, stretching from every battlefield and patriot grave to every living heart and hearthstone all over the broad land, will yet swell the chorus of union when again touched, as surely they will be, by the better angels of our nature. But those better angels of our nature would have to wait on 4 years for the demons of war to work out this conflict that could not be solved by reasonable men sitting down together. Thanks.
Thank you very much, Don. I think we'll turn to Andrew first and sort of move chronologically.
Great.
So.
Oh, it's okay. It's live. Great. Well, I'm very pleased to be here, and I want to thank, first of all, Sonia Michel and the Wilson Center for inviting me to participate in this event, and also to thank Don Doyle for writing such a book that's such a pleasure to comment on it and to speak about. I think one of the things that makes, the basic thing that makes a very good edited volume is obviously very good essays. I think and this certainly has that. This goes beyond that to a new level, I think, because the essays are such an interesting juxtaposition, not just a juxtaposition of perspectives on secession or even on the American Civil War, but also a juxtaposition of different disciplines. We have historians, of course, there are political scientists, philosophers, and legal scholars. And I think part of the pleasure of reading and commenting on this volume is thinking about these justifications between different disciplines and different ways to approach the problem of secession. And so for that alone, I think this is a really fine book. And I think at the risk of maybe just proliferating juxtapositions, I thought I'd give 3 juxtapositions of my own as a way of commenting. 2 methodological juxtapositions, and then 1 historiographical point about the Confederacy itself. So my first methodological point is a point about the relationship between the legal and philosophical accounts of secession and the historical fact and the historical relation between secession and war. The volume opens with a number of very good and provocative and fascinating essays about the legality and the morality of secession from both a legal and a philosophical standpoint. In his introduction to the volume, Don Doyle begins with a couplet by the philosopher political philosopher James Harrington, that casts doubt, I think, perhaps on the validity of, or not maybe relativizes the validity of philosophical and legalistic approaches to secession. And let me read the couplet because I also like it very much, and it's a pleasure to read. Harrington writes, "Treason doth never prosper. What's the reason? Why, if it prosper, none dare call it treason." That is, the justification for secession does not precede secession, but follows secession. It's a fact that's established by a successful secession. Secession is, by definition, a fracturing of the community of law, whether it's a law of in a conventional understanding of law, moral law, philosophical laws, and so forth. That is, the fact of suggestion suggests that there are two parties that don't agree on a common sovereign who could act as a neutral third party. Now, oftentimes, and in several of these essays, international law is presented as a neutral third party. Of course, there's always the problem then of, do the two parties accept the third party as a neutral third party? Is there a fourth party that would then compel the two to accept that third party, and so forth? And I hope perhaps Oleksandr, who's a specialist in international law, will comment on that more. In an essay by David Armitage in this first theoretical section, he makes a very interesting connection between secession then and civil war. Secession is, in a sense, logically related to civil war. But then he also points out that just as secession is a contested term, that is just as the question of whether something is secession or treason is really an outcome of the force of really an outcome of armed conflict, or often of armed conflict, or potential armed conflict, so too is whether something is a civil war an outcome of armed conflict. Since war can exist only between two sovereign entities, and a secessionist conflict is precisely a conflict over whether there are two sovereign entities. And we certainly see this in the problem of naming the conflict that we now call the Civil War, which was originally called the War of the Rebellion, and not a civil war. But of course, and then of course in the diplomacy, whether or not how the Union would address the Confederacy and address the conflict as a civil war had all kinds of implications in international law. So even just the language about which one discusses it is, in a sense, fascinating and contested, but also contested as a form of language that doesn't precede violence, but language that actually emerges from violence, definitions that are actually based on arms rather than arms that then proceed from definitions. Additionally, another fascinating aspect in which the question of war and secession is related specifically to the American Civil War is the question of slavery. One of the justifications, one of the very old justifications for slavery, one given, for example, by John Locke, or at least as an explanation of slavery, is that slavery is justified by a fact of war. There was, at least in theory, a war between slaveholder and slave. The one who became slaveholder could have killed the person who became slave. Therefore, enslaving is sort of like killing, taking away freedom, but not physical life. If killing is justified in war, then enslaving is too. In this reading of slavery, that is the specific cause of the specific secession, that is sort of the prime comparative case here, there's already the very nature of secession, the very nature of slavery, rather, is already war, whether explicit or suspended. And so that slave uprisings, John Brown's insurgency, and the whole course of war was, in a sense, already implicit in the very idea of slavery. Now, this may be one of the reasons why apologists for slavery in the South rarely brought up this justification and instead relied on paternalism and racism and white supremacy as a justification. The second methodological point I want to make is about relating comparative and transnational approaches to secession. One of the debates that's come up in transnational history, and I think perhaps more in German discussions than in U.S. discussions, but it's an interesting point in any case, is a question of whether transnational history doesn't make comparative history either difficult or impossible. The impossible argument, which I should say in the beginning I'm not sympathetic to, I think more transnational history makes comparative history even more interesting. But the people who say it's impossible say, imagine a laboratory with 3 petri dishes. You're comparing them at the same time as the cultures in those petri dishes are growing across each other and infecting each other. That is, if there is transnational history, if there's this dense web of what people often call entangled histories, then how can you separate out these cases for comparison? And I would say, I mean, it's just yet another factor, yet another reason why comparative history is still so interesting and so much fun, and transnational history is so valid to both. Many of the essays make the point that Southern secession is not a separate case that can be compared to others apart from its entanglements. One essay by the historian Andres Reséndez writes, and I just want to quote from this essay, by the time of the Texas Revolution, secessionism was already a well-established type of political movement in the Gulf of Mexico basin. That is, Reséndez, in his essay, makes a persuasive case that secession was actually a kind of political action that occurred around the basin of the Gulf of Mexico, and that Southern secession, well, not, of course, entirely, no case can be entirely explained by its transnational entanglements, has to be understood that way also. We can then begin to see secession as part of a transnational history that includes U.S. imperial expansion, includes rejections of Spanish empire, and also includes expansion of slaveholding as a political and economic form. Other essays, and I'm thinking especially of an essay by Paul Quigley in the volume, make clear that comparison is something that transnational actors themselves do. So not only is transnational history something that historians do to comparative cases, but comparison is something that transnational actors do to their own cases. This is confusing. I mean, it's sort of like the Hall of Mirrors aspect. Quigley points out that Confederate apologists sought to compare their own struggle with national independence movements going on either just before or some continuing into during the Civil War in Hungary, Italy, Poland, Germany, Ireland, and elsewhere. Now, one problem they faced is that these movements were self-consciously emancipatory movements and opposed slavery and often used the language of anti-slavery even in some of their rhetoric, and that many members of these movements have been exiled to the United States, and not only by reasons of where they ended up living in the United States, but also out of conviction, ended up fighting for the Union against the Confederacy. So members of these independence movements did not, with some exceptions, did not connect their own independence movement to Southern independence. It's also the rhetoric of comparison with secessionist movements is not only contemporary comparisons. The volume concludes with an essay by Alan Wachman, who shows how the U.S. Civil War is used today in the People's Republic of China as part of rhetorical justification to oppose Taiwanese independence. So I think that the comparison is still possible, and transnational aspects make these comparisons even more interesting. And I think the essays themselves address this issue, and I think that's another one of the things that I think is really provocative and enjoyable to discuss in this volume. The third point I want to make is a third justification is an historiographical point about the Confederacy. And it's one in which I want to call into question the extent to which secession is the best way to understand the Confederacy. And I say this not because I disagree that secession is the best way, but because I want to call attention to some of the things that aren't necessarily compared in the case, and to contribute to maybe to add another element to the discussion. Secession can be seen, especially if we think about it as a transnational phenomenon of the Gulf of Mexico, as a military means, and as a military means to varying political ends. And the political end of secession in this case was to achieve federal government protection for slavery. So one thing to say is that it's really not, that secession is an aspect of it, but just as there were all kinds of means to achieve this end, the end itself was not secession, but the end was about slavery and specifically getting federal protection for slavery. Another way to think about the Confederacy, not as secession, is not merely to think of secession as a means to an end that was external to secession, but rather to think about the Confederacy not as a secessionist movement, but rather as a movement of integration, of political integration, and of state formation, or kind of three kinds of anti-secessions. So, and let me talk about this in three ways. First of all, one of the things we could say about the Confederacy is that it was not about the autonomy of states, or sometimes neo-Confederates today say it's about states' rights. And certainly the Confederate States of America, the states had no more states' rights than in the United States of America. The Confederate States the Constitution provided for expansion of slavery into territories into further territories outside the current Confederacy, and even many Confederates looked to, and both before and during the Confederacy, and then many pro-slavery apologists and activists, even before the Civil War, looked toward expanding into a kind of Mediterranean plantation slave empire. The historian Matthew Gutterall has recently written a book called American Mediterranean, and the title, I think, explains a lot about the thesis that for many slaveholders, the model wasn't simply creating states where they could hold slaves. That was something they could do in the United States as it was, but rather expanding into really a trans-Mediterranean empire. So one is the creation of an expansive slave empire, not state autonomy, and secession from the United States is simply a means to that end. A second kind of integration isn't really talking about transforming boundaries of states, but rather a kind of integration or consolidation internally. The historian Stephanie McCurry, in her recent book, Confederate Reckoning, has argued that the Confederacy was really about creating, first of all, certainly a state based on white male supremacy, but precisely the conditions of secession and war demanded the political activities of precisely the people that the white men in charge of the Confederacy, for whose benefit the Confederacy was to be. It depended on the participation and the heightened participation of women and blacks. That is, precisely the people who were to be excluded from political representation were to be included as political subjects. And the title of the book, Confederate Reckoning, suggests how that actually works out. That is actually the absurdity of the idea of creating an empire, creating a nation, demanding the increased political and economic participation of precisely the people it was designed to keep down was let's say an unlikely proposition that indeed didn't work out. And finally, a third kind of way that the Confederacy can be seen not only as a secession but also as a creation is to think about it as the creation of a new kind of series of reactionary states, a series of reactionary states that emerged after the 1848 revolutions, when the old kind, it's an old kind of reaction that wasn't so much in the United States but in Europe, the old kind of crown and altar reaction became unviable, that holy alliances, as it was called in Europe, wasn't going to hold out against revolution. And elites sought to preserve old-class hierarchies with new kinds of rhetorics of revolution and democracy even. The classic case is Napoleon III with his Bonapartist state, and Bonapartism has, of course, become a social scientific category that's been used to explain, for example, Bismarck's Germany, but we can use to explain a whole host of these modern reactionary or modern conservative states that emerged. Certainly, the Confederate rhetoric against what they called black Republicans borrowed a lot from the contemporary European rhetoric against red Republicans. And I think that we can see the Confederacy also as the consolidation of new kinds of states. One new thing that the Confederacy maybe contributed, perhaps uniquely, was a state not based, and a hierarchy based not on blood as aristocracy, but blood as race. That is, it was a state based on, specifically on racism. And while racism is certainly brutal and barbaric, it's also a modern form of brutality, and not something that was ancient. So these are three thoughts, two methodological and one historiographical, that I wanted to juxtapose with all the great juxtapositions in this book. I just want to conclude by thanking Don Doyle again for bringing together all these essays, and also Sonia Michel for bringing together this forum where we can continue to juxtapose all these juxtapositions.
Thank you, Andrew. You can see from this how powerful transnational comparative history can be, and you can also tell that from Don's talk and from the volume, but it's also mind-boggling. I'm having trouble keeping all of these cases in mind, but maybe Oleksandr will bring us back to ground a little bit.
Thank you very much. I'll try to give you a brief outline of what is the situation with international law with respect to secession and this phenomena. First of all, it's a great pleasure to talk about this book because it gives lots of materials, lots of food for thought for specialists on international law. And I really enjoyed reading this book. It's not, I would say it's not, if, for example, this book would be written from strictly legal point of view, it would be really boring and not interesting. When we're talking about right to secession, the problem here is that whether there is such a right recognized by contemporary international law. In most cases, specialists on international law tend to talk about a principle of equality and self-determination of nations. This is one of the key principles on which contemporary international law is based upon. And within framework of this principle of self-determination, we're talking about right to self-determination. And the question here might be formulated in the following way: whether right to secession is part of this right to self-determination. And this is the point where specialists on international law have different, divergent, diametrically opposed opinions. From the very beginning, I would like to stress that majority of specialists in international law, they deny this right to secession. But some of them, which is not mainstream, which is minority, they support it. This right to secession is a very painful issue for contemporary doctrine, contemporary theory of international law, and practice of international relations. And it raises many very interesting issues. First of all, as I mentioned, the first question is whether right to secession is part of right to self-determination. You see, when we're talking about right to self-determination, most books on international law, they argue that it's one of the most sacred human rights, right to self-determination. But the question is here where it stops. Another question is how this right to self-determination is compared with other major principles of international law, in particular with the principle of territorial integrity. And there are 3 points of view in contemporary legal, international legal discourse. According to first point of view, right to self-determination is more important than the right to territorial integrity of state. Second point of view maintains that territorial integrity is more important, and right to self-determination must be subordinated to this right. And finally, the third point of view, which is sort of compromise, that both these principles of international law, they have equal legal force, so which doesn't answer our question. A third question is also very important. Who is the subject of right to self-determination and ipso facto right to secession? We also can give different answers to this question. First of all, it can be nation, but the problem is with this term, with this word nation. What is exactly meant by that? For example, by nation we might mean national minority, or we might mean state. For instance, if we take the name of United Nations organization, we know from its charter that it's made up of states, and only states can be member states, members of this universal international organization. And they're talking about other subjects of self-determination. People might be another subject, or state itself, or national minority. So it's not quite clear who is the subject of this right to self-determination, the right to secession, if it exists. And a final question which can be raised in this context is, what are alternatives to secession? Because in many cases, as Oleksandr Tarasov, who is a Russian sociologist, he says that there are only two alternatives to democratic right to secession, which is forcible segregation or even genocide. And from historical perspective, we can say that there are many cases when genocide was used, like in Darfur, for example, in order to prevent secession. A few words about Soviet approach and contemporary Russian school with respect to right to secession. It's very interesting because we have in the territory of the former Soviet Union at least 5 entities which claim this right to secession and right to self-determination. Transnistria in Moldova, Nagorno-Karabakh in the territory of Azerbaijan, in Georgia it's Ossetia and Abkhazia, and of course Chechnya, which had this war for liberation, for national liberation, and this movement, as we know, was brutally suppressed. It's very interesting because, you see, if we take Soviet textbooks or Soviet monographs devoted to self-determination, Soviet school understood self-determination in a very broad way as including right to secession. And the question is why? Because in 1914, Lenin has published a very interesting article right in the middle of the World War I, and it was called, its title was on the Right of Nations to Self-Determination. It was a question about future of Poland. And he was a staunch proponent, he was in favor of broad understanding of self-determination, including right to secession. And he was a very staunch proponent of this thesis. So for this reason, for ideological reasons, a Soviet School of International Law just couldn't deny this right to secession. And for example, according to Soviet constitution, Ukraine and other Soviet republics, they had this right. They were sovereign states officially, which later, it was of course nominal sovereignty, but later it gave a real opportunity to secede from Soviet Union. So even though this norm was, so to speak, dormant in Soviet constitution, but later it allowed to secede. And if we take, for example, the last course, very academic, very popular course on international law published in the late 80s, beginning of 90s, till the collapse and disintegration of Soviet Union, you can see very vividly that Soviet specialists on international law recognized right to secession. And I think that it gave, at that point, right to those territorial entities which proclaimed independence, legal ground to secede. And situation started to change with Russian School of International Law when the problem of Chechnya emerged. And you can see if you read articles or textbooks by Russian specialists on international law that they try to find arguments against secession. And mostly they use arguments published later in the literature of such countries as England, which for ideological reason was against right to secession. At the same time, the concept of self-determination proclaimed by Lenin was contrasted with the concept of Woodrow Wilson. Because as we know that in his 14 points, he also wrote about, he presented this idea of self-determination. Now, yeah, and one more important thing, that Russian and Soviet School of International Law viewed this principle of self-determination initially as political one. And starting with the year 1945, it's viewed as a legal principle, because Soviet Union insisted on inclusion at the San Francisco Conference, where UN Charter was prepared. Soviet Union insisted on inclusion of this principle in the Charter of the United Nations. And since that moment, we can talk about right to self-determination as a legal principle, principle of international law. Now we have a problem in international law of the so-called non-recognized states. And it's a problem. And at the same time, we should also mention here as a very interesting precedent recognition of Kosovo, which used to be one of the non-recognized states, but now Russian specialists on international law claim that recognition of Kosovo's independence opened Pandora box. But it's very interesting, not legal but political precedent. I raised several issues, but you see, in most cases, our view and answers to these questions depend on how we view the very essence of international law. There are two schools of thought, predominant schools of thought. The first one is positivistic, legal positivism, and the majority of lawyers, international lawyers, they're positivists. It is meant that the major subject of international law is state, and international law is created by states for their own purposes. And of course, these states are not interested in secession because it means sort of suicide for them. They're not interested. So for this reason, for these theoretical reasons, followers of legal positivism denied right to secession. On the other hand, we shouldn't forget that there is in minority, but still rather influential school of thought, which can be called a school of natural law, lex naturalis or lex naturale. And according to this school of thought, international law is not state-centric. It's rather anthropocentric. So human being and human rights play the most important role in international law. And for this reason, this school of thought allows secession when human rights are violated and when there is a need to protect human rights. This is about it, and I just wanted to stress that it's not everything is clear-cut in contemporary theory of international law, and secession is a process. It continues, and it would be interesting to see what will happen, for example, in Russia in 10 or 15 years, whether it will be one state or, as according to some political forecasts, it might split into several countries. The same can happen in Ukraine, actually. Yeah, we cannot deny this. So thank you very much for your attention.
Thank you very much. Well, these are three fascinating and complex presentations, and our panelists will now entertain your comments and questions. This gentleman right here. Yeah. Please identify yourself.
Sure. I'm Brian Beery, journalist for CQ Press. I think my question is more for Oleksandr. I'm just wondering, the key issue about the right to secession versus the right to self-determination. The countries around the world and the main governments around the world, do they have a consistent position on this? Because it seems to me that there isn't a very consistent position. You know, classically with Kosovo, Russia says, it doesn't have the right to secede, and then, of course, Abkhazia and South Ossetia do have the right to secede. So I'm just wondering, from your studies, is it just very ad hoc and countries just basically pick and choose where they apply which principle, or can you make more broader conclusions about where countries tend to fall on this debate?
Yeah, thank you. First of all, those countries which have problems of separatism in their territories, of course, they tend to deny right to secession for obvious reasons, like England, like Spain, and like Russia also. But you can find, you see, when you read legal documents like UN Charter or a Declaration of Principles of International Law of 1970, when it comes to the content, legal content of this right to self-determination, this principle of equality of nations and self-determination, is relatively vague. So you can draw different conclusions. And talking about literature on international law, you can find their arguments in favor and against secession. There is, for example, such an argument as if international law is based on consent of states, and if, for example, secession is not prohibited, it should be allowed. Because by its nature, it's very dispositive, I mean international law. I made sort of an experiment. There was a conference in Kyiv devoted to the legal status of Transnistria. And I was present at that conference, and a friend of mine who is a specialist on theory of law, he tried to protect international legal status of Transnistria. But unfortunately, he didn't know well enough peculiarities of international law, and I published an article, and I gathered all the arguments in favor of secession, which started like an intellectual experiment, rather. But that article, which was published on the internet, to my amazement, it was reprinted on the sites of those territories which claim the right to secession. But to sum up, if we take international legal literature, it's not this question whether secession is allowed or not by international law, it's not decided in a definitive way yet. It remains to be an open question.
Yeah, in the very back there. Yeah. Well, let's try. Yeah.
Thank you, Sonia. I'm Charles Mayer. I'm a fellow here this semester. This stuff is fascinating. I mean, on the general points, too. I'm all for comparative history. It's not abolished by transnational, but that's not the issue. I'm just thinking of some of the particularities of the situation today. Obviously, when you get a supranational framework, like the EU, it makes the possibility of separation in some ways much easier. You have quasi-direct relations even with a pretty ensconced territory like Bavaria and Brussels, and so anybody opting out can say, well, we'll nest we have a larger nest within which we find ourselves, and this was clearly at the high point of nationalism in the 19th century. and not the case. I was listening to, Lincoln's oratory is overwhelming, but it's not just that these countries would be neighbors, but it seems one of the big stakes, and maybe it's taken up, and you're a scholar of this. I haven't read the book yet, although my wife, who's a historian, was getting interested in this stuff and asked for your earlier book. It's that there was a huge stake about empty land, relatively empty land next door. And so without the stake of expansion for both the South and the North, which had already been preluded in Kansas, Nebraska, etc., perhaps the outcome would have been different. So it's not as if we two partners in the marriage couldn't avoid each other. They had a really big property, claim in this thing, and or a potential inheritance coming that was at stake. And I just wonder, in the arguments about divorce, it sounds appealing, but divorces don't look to the origins of marriages usually. They look to the conditions of them. And it seems to me that a large matter in whether it was Nigeria or in places in the Soviet Union or in other, or even in the former Yugoslavia created in the question of what sort of origin was at stake, coerced implicitly or a free union has to be crucial into probably in this, even when there's quite a bit of remote time. And I wonder whether any of your contributors pushed this issue in some way.
Don?
There are none that go back into the kind of arguments that South Carolina was making about the origins of the marriage, and in their case 1788. But boy, South Carolina sure did at the time, and they wanted to make clear that this was a consensual union, voluntary, and in which the state retained some sovereignty and the right to withdraw once the contract was breached.
But the argument could be reversed. In a coerced union, perhaps there was just as much justification for breaking it up.
Yes, that's. Mm-hmm.
Michael, yeah.
Michael Kimmage, Catholic University. Don, I know that you spoke out against American exceptionalism, but I did have a question in this regard. Hearing these examples of the breakup of the Soviet Union, it seems odd, at least on its surface, that the South broke from the North for rather abstract reasons, that there wasn't an ethnic or religious division, and in some ways it was against the economic interest of the South to secede. So in that sense, could one describe the secession of the South as exceptional in the history of secessions?
You can find a lot of different examples. I think that Europeans did have a hard time understanding, is this a nation or just a compact? It doesn't seem to be based in blood and language, soil and history in the way that at least we imagine Europeans thinking of the nation. And instead the Americans were coming over to the courts of Europe and giving these legalistic arguments about what happened back in 1789, and it was puzzling for them. The whole terminology of states and states' rights and federal government was a little puzzling to the foreign world generally. But I think they were also very aware that nations were being made. In Italy, for example, was the most timely parallel, and it was the example that the Confederate States of America took to Britain and said, look, you have just recognized this country that has been put together. It's not based in even a common language at that time, but put together through liberation or conquest, depending on your point of view, as to what Garibaldi was doing in the South. But Italy is made, as they say, and as they said at the time, and not just a risorgimento of an existing nation. So I think there was an awareness, but also in the United Kingdom. I've said somewhat in jest, but anytime you see a country that has united or union in it, it almost always means some history of coercion and forced integration of different groups. So I don't think it was quite entirely that that different. But underlying this was this idea of nations that America upheld that were self-governing, that were republics, that were based on principles rather than on blood and soil and history and so on. And I think that becomes very important.
Just, from using your sort of vast overview, or inventory of these cases, how many of them would you say are ideological as opposed to sense of ethnicity, of being a people kind of thing?
Well, mind you, these get confused and mixed up, and the South, I should point out, begins to trot out all kinds of ethno-cultural arguments about them coming from the Cavaliers from England, and a lot of these ideas get played out. Andrew was talking about race as becoming a central theme. One of the propagandists overseas, a young Swiss immigrant, who now becomes the head of Confederate propaganda in Britain, Henry Hoates, a devoted fan of Gobineau, whose essay on the inequality of the human races becomes central to his idea that we must create a forward-looking, progressive, if you will, racist, white supremacist nation rather than a nation that would be based on slavery and these older, archaic institutions. So it's a reactionary regime, but he's trying to, as you suggested, Andrew, dress it in this kind of modern scientific dress based on modern scientific concepts of racism.
This gentleman over here.
Hi, Jim Lowen. I'm the author of The Confederate and Neo-Confederate Reader, so it has some relevance to what we're talking about. And I want to say I wrote this piece in the Washington Post early in January that went viral, and I got all kinds of emails from hundreds of Sons of Confederate Veterans types, which taught me that I had not problematized something that maybe I should have. And you talked about it some. And that is, why was there a war? Now, I always say, well, there was a war because there was secession. But, of course, secession, as you point out, there isn't always a war. The two Pakistans split, and there wasn't much of a war anyway, and so on. So why was there a war? And it seemed, and then many of my neo-Confederate correspondents demonized Lincoln. He did it. But, of course, if he hadn't accepted war, at least, and done some things to bring it about, he wouldn't have had any following at all. I mean, it was the majority position in the North, especially after Sumter. And I'm wondering, weren't there lots of Confederates, I've read that there were, especially in South Carolina, who not only expected that there would be a war, but wanted one, and in fact, in some cases, who acted so as to provoke one. But I wonder if you could just comment with all your thinking about this, because I hadn't done as much as I should have. Why did secession, of course, lead to war? Because it isn't quite the of course that I thought it was.
I think that Lincoln is to be either credited or blamed, but assigned responsibility for the decision of the Union to resist secession. And I'm trying to say that in as neutral a way as I can, because I think that's the truth. Many, yeah, but many in the Confederacy did believe that they had a case to go before the world of nations. And here, Oleksandr's ideas about international law become really important to this concept that there are some kind of rules of ethics about which nations deserve to exist. And they felt like they had a case, and that that slavery was not an issue. And Lincoln, in that first inaugural address, took it off the table. He said, look, we're not trying to preserve slavery. That's already been guaranteed. So if France and Britain, if the governments had recognized the Confederate States, there would have been a very short war or none at all. They would have, it would have ended. And they sent envoys out to the nations of the world, expecting to get recognition. I think that's where the real game was, and that the field of battle went on for 4 years indecisively. So there was a realistic belief that they might get secession with just a show of force. After Bull Run, tremendous hope in July 1861 that they would get recognition. An expectation in Europe that it was finished. The United States was divided forever.
I would say that is war already, though. After
Yes, but a very short one.
Yeah.
Yeah, right here.
My name is Stephen Shore. Brief comment and then a question. It seems to me that recognition, however much it may have helped soothe egos in Richmond, in the absence of a war against the Union to break the Union blockade, would not have really accomplished anything materially. My main question, though, is you've not spoken about conquest and decolonization. When looking at the Soviet example, the fact that the official Soviet position in the Baltics was that these nations had voluntarily chosen incorporation, and the paradox of this argument was it made their independence harder to resist, because if they voluntarily chose incorporation once, then in theory they could have chosen to repudiate it at a future time, whereas if they had been conquered outright, like Karelia was conquered, and simply by the act of conquering Karelia, of course, virtually everyone of Finnish descent left. But had they stayed and wanted to leave the Soviet Union, by definition, they would now be separatists. But the other aspect no one has spoken about is the role of separatism in the decolonization process. One could view Cyprus, the Israeli-Palestinian conflict, Bangladesh, certainly, and Algeria, which was formerly annexed by France, as a successful separatist struggle, depending on one's point of view.
And certainly the United States, in its beginnings, began with that very much then.
Anybody else want to comment?
Yeah, very briefly, and this is also in reference to what was asked about origins of those families. You see, the critical date in the history of international law, which separates contemporary international law from the classic or traditional, is 1945, because beginning with 1945, with the adoption of UN Charter, we have a new principle on which international law is based, which is principle of the non-use of force which, in international relations, which prohibits war. But before that, there was an institution of international law, jus ad bellum, right to go to war, basically. And of course, many, maybe most, or all of the country states, they live in the territories which were conquered. So all these marriages were arranged and forceful, you see. And beginning with 1945, it's not legally allowed to conquer. I'm not mentioning here Brian Kellogg Pact. It was an attempt to ban war, but still the critical date is adoption of UN Charter. So.
I'm glad you...
Pull closer.
Oh.
Yeah.
I'm glad you brought up decolonization also, because I think that's just a really important, interesting comparative case. And just one thought that occurs to me on that topic is that decolonization, I mean, the Algeria exception is I think that's an interesting counterpoint, but typically involves seizing a state apparatus and maintaining it, but just kicking out it's in a sense, it's going from a state of occupation to getting rid of the occupation, but there's not actually, at least at first, a redrawing of political boundaries or even a complete transformation of the state apparatus. So that may be a point where that is not the same as secession. But I think I'm glad that that's part of the discussion too.
Yeah, Philip. Yeah, Richard. Do. Yeah.
Thanks. Philippa Strum, thanks so much. It's really fascinating. I wonder if you could talk a little bit about the limits of the concept of self-determination and where it comes up against the idea of secession. And it seems to me you've talked about it, in qualitative terms, if I may. What is a just cause? Do you have to have a just cause, or is the simple fact of choice or self-determination, perhaps? sufficient. But I'm wondering what the literature, both of secession and international law, says about what you might call quantitative. Is there any indication of how large an entity has to be involved for something to be legitimate? Could I, under the literature, tomorrow decide to secede? And if not, why, in a quantitative situation as opposed to qualitative?
The Republic of Flip.
Alan Buchanan raises the question, shall every person's yard be their own nation at some point? One opponent of secession in South Carolina famously said, or is reputed to have said, that it was too small to be a republic, too large to be an insane asylum. James Pettigrew. But that certainly, I think there is another question. I tried to raise this in the introduction, that beyond the sum of the individual parts claiming self-determination and a place in the sun, is this good for the world to have 5,000 different nation states, each based on some idea that we are homogeneous, we are a family, you are not? It seems like even if you could or wanted to divide up the world in that way, everyone has to stay in place. They can't cross borders, or they're out of their nation. And I'm not sure, do we want a world like that? But that's I think, going beyond the question that individual aspiring nations have to claim the right to self-determination. I would let Oleksandr perhaps take that up.
Yeah, I'll try to answer, because you see, one thing when we have a nation which aspires to become a state, and another thing when we have a state which emerged. And the problem here is that this process of emergence of state is more a problem of, it's a question of fact, not law, because, and it's a problem of politics rather than law. Because the classic definition of state is that it's made up of three components. It's territory, population, and government. And if, for example, certain national minority is strong enough to get control of a certain territory, it has, I'm not sure, because in terms of quantity, I cannot answer how many people should be in this national minority. And there is a government which is ineffective control over this population and this territory. We have a state. So, but the state is born from the fact. And fact of politics, fact of sometimes brutal force. And for this reason, in legal literature, right to self-determination is sometimes referred to as a bloody right, because in order to get self-determination, to create state, you need to fight. There is sometimes you might have a war for national liberation. And some national minorities are successful in this respect, like Kosovars, who created their state. Others were suppressed, like Chechens. You see, because Russian government, federal forces, they proved to be stronger than this national minority which wanted to create its own state. So it's more issue of politics than law. And when we're talking politics, we're talking about force. Who is stronger? Right? Might makes right in this case.
Andrew, did you want to jump in on this? Yes, please. Yeah, Marjorie.
I had a question. I'm intrigued by what you're saying about how post-45 international law changes, and there's less, I gather, acceptance of the idea of seizing lands through imperialist ventures. And I was thinking that in the 19th century, during one of the main issues surrounding European attitudes towards the American Civil War, as Don is finding in his current research, has to do partly with European battles between the forces of liberalism and republicanism on the one hand, and monarchy, clericalism on the other. But it also has to do with the European powers' ideas that they wanted to retake territory in South America, and that the U.S. had professed the Monroe Doctrine, and somehow if the America's republic divided, that would clear the way. And so I'm wondering, how, if either of you would comment on that. I mean, is this one of the issues that was at stake with the American Civil War? I mean, had the United States divided, would that have given free rein once again? I mean, obviously, on the other side of the Atlantic, going into Africa, they were not exactly being shy about imperialism, but when it came to the Americas, it was a different matter.
France had already invaded. France, Britain, and Spain made a tripartite alliance, invaded Mexico, or at least came to Mexico to collect debts. France went on, invaded it, installed a Habsburg monarch, and had in mind not just restoring Mexico to monarchy, but taking over, taking back, they would say, the Western United States, and creating an alliance across South America that would be devoted to monarchy and to a Latin Catholic empire. And British upper classes looked with glee on what they called the bursting of the Republican bubble and predicted that the United States would be broken not just in 2, but in 4 or 5. Once the Confederacy controlled the Mississippi, they would also, they envisioned, control the upper Midwest, not because it would be safe for slavery per se, but it would have to make alliance with the Confederacy. So there were some grand designs by Napoleon III, the Confederates, and this was, and the British, meanwhile, mounting their forces in Canada. This was the end of the Great Republic if those governments in Europe had had their way.
Just a short comment on a very interesting issue about doctrine of Monroe. In the 30s, there was interesting attempt by a German legal thinker, Carl Schmitt, to create, on the basis of Monroe Doctrine, theory of Grossraum, which shouldn't be confused with Lebensraum of Haushofer. So he argued that we should legalize this situation when we have hegemonic state in the region, which is in control and has a specific exceptional rights with respect to its neighbors, for example. It's in charge, sort of. But it was more political concept. It was not successful. In this way, he tried to justify claims of Germany and Third Reich in order to subjugate Europe. But in politics, this concept still is alive. Yeah.
And modeled on the Monroe Doctrine, correct?
Yeah.
Yeah.
I'll just jump in here a little bit. Flip's question and your response, Don, raised something that, for me, something that I think about often. I mean, yes, it's true if smaller and smaller entities claim the right to self-determination, we end up with a very fragmented world. But you might also think about the possibility of a post-national world. And I think Charlie's question also raises this issue, you know, the idea of the EU, or, I mean, certainly in this age of globalization, and where, you know, as Charlie said the other day in his presentation of his work in progress, the fact that so many of us carry multiple passports, people migrate all the time, you know, doesn't, I mean, in the course of your work on secession, have you thought about the possibility of, you know, at least fantasizing about the possibility of a post-national world and how we might get there, if that is indeed desirable? Maybe the others have some thoughts too.
I don't know if we'll get to a post-nation state world, and I think what a lot of people have suggested is that what we're seeing is, you know, these forces of globalization and supranational organizations like the EU creating, as Charlie Mayer said, you know, kind of new nets in which people can be caught or supported as. Also, the fragmentation, and is it a reaction to that globalizing world? Suddenly, out of nowhere, we get a Scottish nationalism. I mean, who would have predicted that this would be? Okay, deep roots of ancient sentiment. But who would have predicted that? And it's somehow these kinds of identities are being are bubbling up within a world that is otherwise seems to be erasing national boundaries or making them less important to to the way that we live.
Well, certainly, as the direction of history has been to question and to denaturalize these national identities.
Yeah.
So, at least in the intellectual world, nationalism and nationality are sort of presented in scare quotes, but maybe that has not migrated to the rest of the world. Other comments, Andrew?
One of the things that's so interesting about the decline of bonded labor, not just in the U.S., but in the New World and the Old World too, is its gradual, well, pretty quick replacement actually with contract labor, with laborers that are indentured and transported long distances. And the employers of these workers, whether it's in Prussian landlords employing Polish migrant laborers, U.S. landlords employing migrant laborers from Mexico, or the employers of Chinese and Indian contract laborers, is that these people are international and stateless. That is, they do not have the protection of a nation state whatsoever. And it's not a utopian, at least on the surface of it, it's not a utopian internationalism, but a dystopian internationalism. It's the rise of, this line from Edmund Burke where he says, I'd rather have the rights of an Englishman than human rights. I may not be quoting him correctly, but that's often quoted, for example, by Hannah Arendt in her discussions of refugees. There's also the utopian possibility, I think probably excessively utopian, of, although hopefully not, of Michael Hart and Antonio Negri in their book Empire, where they see in these increasing, really the population of the present that's really emerges out of this, from the fixity of bonded labor to the kind of complete subjugation to unprotected subjugation of the migrant. They see this as the possibility of a new post-national emancipatory democratic international. So far, the signs, I haven't seen many of the signs for that yet, but hopefully they're right. But that's certainly, I think, one of the key global processes here.
A brief comment, if you don't mind. You see, when I first traveled in European Union, I was shocked to see that there are, in fact, no borders. And I was surprised peoples and nations of Europe were fighting very brutally for ages for these borders, and all of a sudden, well, it's amazing. And in this respect, I consider myself to be unrepentant cosmopolitan and utopianist, because I believe in what John Lennon sang in his song Imagine, so no borders, no states, there is no reason to fight for. And one of the projects of international law is called Cosmopoliticus. So this is law of it goes back to Immanuel Kant and his idea to the perpetual peace. He believed in this world federation, and Antonio Negri, they mentioned that there is no need to have this citizenship and passports. And I think that after all, we're all human beings and belong to one family, human family. And we don't need borders. We don't need our own prisons like states, and we should freely travel. It's one of the most important human rights.
Well, what do you say with that to the contemporary virtually stateless workers who are, like say, people working without papers here or in so many other countries? In a sense, they've achieved this cosmopolitanism, and yet there's something lacking. Yeah. What's the international law?
First of all, well, international law is more state-centric. It continues to be state-centric, even though I consider myself to be more representative of natural law. You see, in this respect, because I think it should be anthropocentric, and these people should be legalized. As at one of rallies, there was a slogan that no person can be illegal.
Yes.
And I think that they come to help this country. They come to work here, and I don't see any reasonable reason to deny their rights. I'm against citizenship and passports.
Right, for all. So yeah, that's right. That makes a lot of sense. Me too.
Well, on that note, I think we've all seceded, or we've all agreed. So if there are no more questions, but I'm sure our speakers will be happy to talk to you one-on-one, and please remember there are books for sale outside, and thank you very much for coming. And thank you very much, panelists.